Next month, the Supreme Court will be hearing oral arguments on the first gun rights case they have taken since Bruen. This case strikes at the heart of the holy grail of gun control, the gun possession prohibitors in federal law. And your National Foundation for Gun Rights just filed an amicus brief telling the Supreme Court that they need to let the lower courts know that they actually do need to obey Bruen. But before I get into all that, stop right now and sign the petition in the description below to join us in fighting for the Second Amendment. And then please like this video and subscribe to our channel to stay up to date on the latest gun rights news. A lot has happened in the last year of gun rights litigation. Bruen completely changed the game for Second Amendment cases by doing away with the two-step analysis the lower courts had used for years to uphold gun control. So basically, they would balance the constitutional right against the supposed societal benefit of the gun control laws. And of course, that was just an excuse for anti-gun judges to rule the way they wanted. The Supreme Court put a stop to that in Bruen and said that from now on, courts have to start with the text of the Second Amendment, and only if there's a historical analog for the gun control can that law be upheld. In other words, gun control must be consistent with the text, history, and tradition of the Second Amendment. And most, if not all, gun control laws will always fail that test. So the last year has been full of some pretty interesting shenanigans on the part of lower court judges, trying to weasel their way around the plain words of Bruen. So our brief, I have a copy of it here, is honestly saying primarily the same thing that our brief in the Bruen case said, that the Second Amendment is not a second-class right, and the Supreme Court needs to force the lower courts to comply with that. But this time around, we're identifying a lot of the bad faith arguments, tricks, and loopholes that the federal judges have used in the past year to circumvent Bruen, and we're asking the Supreme Court to straighten these out. For instance, just a couple examples of the lies that we've gotten in our cases from judges supposedly applying Bruen. They say that guns that are commonly possessed are not protected by the Second Amendment because they're similar to military weapons, which is nonsense and not at all what the Supreme Court has said. That's a deliberate twisting of precedent to avoid having to strike down semi-auto bans, as a lot of our cases are asking them to do. Another example that we mention in our brief. Not everyone is initially part of the people referred to by the Second Amendment's text, that the right of the people to keep and bear arms shall not be infringed, which is also nonsense, and we're asking the court to clarify that all people are in fact people. Now, fortunately, we only have one Supreme Court justice who doesn't know what a woman is, so the rest of them should hopefully be pretty clear on how to define people. We're also pointing out that courts are saying that if a weapon is too dangerous, it is not protected by the Second Amendment. And that's another distortion of the Supreme Court's words, and we're asking them to straighten that out as well. As our lawyer said in the brief itself, all weapons are dangerous. And if Second Amendment protection hangs on whether a reviewing court decides to hang the epithet, particularly onto dangerous, to describe the weapon, the Second Amendment is rendered toothless. And then there's the old gun grabber favorite. Common use means you actually have to use the gun for self-defense or it's not protected by the Second Amendment. And that is such a lie. The Second Amendment right includes the word keep, as in keep and bear arms, and that means to possess. The Supreme Court has said that, but lower courts have twisted that so much in our cases to overturn so-called assault weapons bans. And here's what we are saying to the Supreme Court on that one. This court has never hinted, much less held, that for an arm to be protected, it is necessary for a plaintiff to show that the weapon's use in actual self-defense situations meets some arbitrary threshold. Heller was decided on a motion to dismiss record. The court did not require an empirical showing regarding actual use of handguns. In Bruen, the court picked up where Heller left off. The court stated that the Second Amendment protects the right to possess and carry weapons in case of confrontation. The right encompasses the right to be armed and ready for offensive or defensive action in case of a conflict with another person. The right thus encompasses the right to keep firearms at the ready for self-defense beyond moments of actual confrontation. Making it all but impossible for plaintiffs to establish common use would frustrate the court's clear purpose in Bruen. Accordingly, NAGR hopes the court will provide guidance regarding this issue. But the most important part of this brief is where we actually attack the gun prohibitor statute at issue in this very case. This particular federal law says that an individual can be deprived of Second Amendment rights whether or not a crime has been committed, and just as the result of a civil hearing. Remember the thrust of our brief? That the Second Amendment is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees, to borrow the words of the Supreme Court itself. Well, here is where this federal gun prohibitor fails that test, and this is what we say about it in our brief. The statute at issue in this case applies to anyone who is the subject of an order that does no more than prohibit him from threatening the use of physical force. There is no requirement that the court make a finding that the person actually made such a threat in the past, intends to make such a threat in the future, or even that he has the ability to carry a threat out if he were to make it. That the government's amici are satisfied with, even applaud, the fact that under the statute a person can be stripped of his fundamental constitutional rights on such flimsy grounds betrays a mindset that does not really consider the right to keep and bear arms as a right to take seriously, much less defend vigorously. Then we go on to say this. Suppose Congress were to enact a statute parallel to this particular law that provides as follows. Any person who is subject to a court order that by its terms explicitly prohibits the threatened use of physical force against an intimate partner must allow the police to search his residence at any time for any reason or no reason. The police need not establish probable cause for any such search. Almost certainly, it would never occur to the government or to its amici to argue that a person has nothing to complain about so long as he has notice in a hearing before entry of a court order that serves as the basis for stripping him of his fundamental right to be free from unreasonable searches. What is the difference? The difference is that this federal statute violates what is, in their view, the second-class Second Amendment right, whereas the hypothetical statute violates a first-class Fourth Amendment right that is worth defending. And we go on to point out that this same mindset plagues the so-called red flag laws that have so recently been enacted in many states. Quote, the bad news is that similar red flag laws that relegate Second Amendment rights to second-class status are proliferating around the country. That legislatures are passing these laws with such apparent insouciance suggests that it is important for the court to re-emphasize its prior holding that the fundamental right to keep and bear arms must not be treated with any less deference than other fundamental rights. That is exactly why this case is so important. And it's essential that the Supreme Court decide here if they really mean it when they say that the Second Amendment is not a second-class right. Because if that's true, then they are going to have to deal with the red flag gun confiscation laws that so many states have passed. This is an even bigger issue because in last year's Cornyn-Murphy gun control package passed by Congress, the federal government offered huge amounts of money to the states to implement red flag laws. And just about every state, red and blue, has taken that money, including Texas, that just recently enacted constitutional carry, and my own home state of South Carolina, places which are the last states you'd look for to be exploring and acting such unconstitutional gun confiscation laws. So it is essential that the Supreme Court take a clear position and crack down once again on gun grabbers in the states and the lower courts alike. The Second Amendment is not a second-class right, and when it says that the right to keep and bear arms shall not be infringed, it means it, and it is time for our country to follow that. So we will keep you posted on how this case goes. Once again, I would ask you to please take a moment to like this video and subscribe to our channel, and take a moment to sign your petition in the description below to join our fight to preserve the Second Amendment.